Imagine this. You're on the way home after a day of work, and out of nowhere, you see blue lights approaching you from the back. In confusion, you stop, turn around, and put your hands up. The policeman gets out of his car and begins to ask you, "Why are you in this neighborhood and where are you headed?" Before you can even answer his question, he proceeds to put your hands up on the wall and pat you down. You ask, "Officer, am I under arrest?" He replies, "No, I was just making sure you weren't carrying any contraband or weapons. Have a great day." And now that he realizes that you aren't a suspect, he goes on about his day. You have just been stopped and frisked. Why? Because you were in the wrong neighborhood with the wrong skin color. This happens to thousands upon thousands of minorities every year, and in many cases, it can be considered justifiable. However, today I'm here to tell you why it shouldn't be justifiable, and instead, it should be outlawed. Stop and frisk was originally made as a method to fight crime and make communities safer. Its original purpose was to be a non-intrusive stop of a suspect by police. The Fourth Amendment requires, according to the Taylor Law Company in 2012, that before stopping the suspect, the police must have a reasonable suspicion that a crime has been, is being, or is about to be committed by the suspect. However, with a method this broad, giving police a lot of power with no one to tell them differently, you can expect for it to be taken advantage of. According to the book Stop and Frisk, The Use and Abuse of a Controversial Policing Tactic in 2016, the stop and frisk will go on to be the central tactic of modern day policing, particularly by the New York City Police Department. The book also mentioned that by 2011, the NYPD had recorded over 685,000 stop and frisk interactions with citizens. According to the Stop and Frisk Handbook in 2012, the stop and frisk method became much more regulated by the NYPD after the Floyd versus City of New York, which challenged the New York City Police Department's practices of racial profiling and unconstitutional stop and frisk of New York City's minorities. The judge in this case ruled that these stops were in violation of the Fourth Amendment, but also on the obvious racial disparities in who was stopped and searched by the NYPD. Approximately 85% of those stopped are Black and Latino, even though these two groups only make up 52% of the city's population, which constitutes a violation of the Equal Protection Clause of the 14th Amendment. However, after stopping a suspect, the NYPD now must fill out a UF-250 form that documents why the suspect was stopped and what is going to be done about it. Every state in the country who uses the stop and frisk method now should use, if not this form, an adaptation of it to keep police accountable for who they are stopping and why they are stopping them. Minorities have been at risk for much too long, and now it is time to change that. Some say that the UF-250 is still going too far because keeping records on innocent people is still in violation of their privacy. However, we cannot let the corruption of the stop and frisk go on any farther. We must push that these UF-250s be put not only into effect in New York and Chicago and many other places with lots of minorities, but in every state that allows the stop and frisk method. Thank you.